there's ramifications for that as well.
But 0.17, Judge, is a long ways from, it seemed to me, from 0.8.
Yeah.
I mean, somebody is there, they're probably drunk.
It's usually very noticeable. Now, not that long ago, the level it started out with 0.15, then they lowered it to 0.10, and then they lowered it to 0.08. A lot of that has to do with federal monies and federal government.
I see.
Putting pressure on the different states to change it. But it's pretty well accepted. Now it's 0.08. A 0.17 is more than double that. Usually the 0.17, the person should know.
Should be getting a designated driver, but
sure,
obviously you're really abusing the law if you're 0.17.
Yeah, and when you say, are there different penalties? For example, on a first offense OVI, the minimum jail is 3. 3 days. High tier, it's 6. They double it. If it's a second offense within 6 years, the minimum jail is 10. On a high tier, it's 20. On a third offense within 6 years, the minimum jail is 30 days. On a high tier, it's 60.
I see.
Now you're sitting there, well, then people say, well, why take the test? Why would I take the breathalyzer if it can only give me double jail? Well, that was happening. So now the legislator created another law that if you refuse to take the test and you've had a prior DUI, then it's considered a high test.
I see.
So if it's first, second, third,
so you're not going to beat it by not.
It automatically will take it to the high tier if you refuse it and you've had a prior within 20 years.
Why does somebody opt not to take the test?
On the refusal?
Yeah.
Okay. Well, the refusal, that's an interesting area, all in and of itself, to be honest with you. It started out as, what you got to remember is, in Ohio, driving is a privilege. It's not a right. No one has a right to drive an automobile in the state of Ohio.
Okay.
It's a privilege bestowed by the state. That's why they can demand that you have a driver's license.
Yeah.
That's why they can say you have to, be a certain age. You have to follow speed limits. We put restrictions on it. And also under the law, we have what we call implied consent. Implied consent is a theory that simply by getting a driver's license, you've already given your consent by implication.
Yeah.
That you'll take a test to determine whether or not you've been drinking. Okay. Now, obviously, when you get stopped, you can't force someone to blow into a machine. So the law was always, well, yes, you have to take the test, but you can refuse because you have, everyone has
a constitutional right
to do it. Now, so what happened? People started refusing, but they put penalties on it. Okay, if you refuse, it's an automatic 1-year suspension. Even if you're found to be not guilty of the DUI or the OVI, you still have a 1-year suspension simply because you refuse to take the test. Well, then more and more people were not taking the test because they said, well, if I take the test, then I'm just giving the police evidence to use against me.
Yeah.
So then the law decided, well, since that's happening, we need to tighten up the law. So what they did is, now, as I indicated, if you refuse to take the test and you've had a prior OVI or DUI conviction within the last 20 years, that's a new charge in and of itself. And part of the element of that is the prior. Let me regress just a second. Normally, in a DUI trial, okay, if you've had priors, the jury's not allowed to know that.
Okay, well,
because we want people either convicted or acquitted on the event of that day, not because of something they've done in the past.
Okay.
So that's a very...
a little evidence, I mean, you can't go back.
In municipal court, that's a very set in stone, that's what we do. Now just think what I just told you. If you refuse it and you have a prior DUI, that's a new charge. An element of that charge is your prior. So now not only can the state bring it in, the state has to prove all your prior OVIs. So now the jury is going to hear that you've had 1, 2, 3 prior DUIs in addition to this one, and I refuse. So then they're going to think, well, the only reason you refused because you were drinking so much, you didn't want to get another DUI.
Yeah.
So think of the ramifications to take that to trial. So now there's a lot of teeth in that if you've had any priors and you refuse, that's going to be a very difficult burden on you to try to beat that charge.
But it sounds like this body of law has continued to change.
Absolutely. Absolutely. In fact, here's another little history on the refusal. Back, again, before they started the new charge, when people refuse it, some courts, it started, guess where, California. California decided, okay, if you refuse a test, the officer would call the local judge. The local judge would say, I'm going to give you an order. Take a blood draw.
Yeah.
So even if you refused it, you get a refusal, then they'd still draw blood and get a and charge you with DUI. And that filtered down, and some of the courts around here were doing that as well. Wayne County did that a lot. The judges had fax machines at their bedrooms.
Oh my
in the middle of the night, they would fax an order. Judge Chase and I were not following that trend, okay? But that was the way it was going. Some courts have said, okay, if you refuse to take the test, then I'm not going to give you driving privileges, okay? Because you did that.
Okay.
So I mean, it's gone a full gamut of, yes, you have a right to refuse to, okay, but if you refuse, we're going to enforce it. Now there's even another law. Now, as we sit here today, the law reads that if you refuse, the police now can take reasonable means to obtain a test.
Without
a
consulting
court
the judge?
Without consulting the judge on their own. They can do reasonable means to get. Now, what does that mean,
Judge?
I don't know. It's not defined.
I mean,
it's not defined, and we've not had any cases yet. It's a matter of time. But yeah, now, obviously, they can't force you to blow into a machine.
But does that mean you could take a syringe to
Yeah, because the only other way is urine, and I don't think they're going to force you to urinate.
Not hardly.
So I think the way it means, they could take their own blood draw. So, and now where we at least had to go to the hospital and have a certified doctor or nurse take it.
Sure.
Now the language seems to indicate the police can do it. None of them have done that yet. But the law. But can you see the progression of the law?
Absolutely. Absolutely.
The legislators have been dictating this and trying to close loopholes.
Yeah, I know people. I mean, clients that I've talked to that had it affixed in their head. They can't make me take that test.
Yeah.
I mean, no way I'm going to take it. But rules of evidence. I suppose in certain proceedings you had prior bad acts or something, you might be able to bring something in. But I do remember the judge I worked for, and this is, as I said, 20 years ago, you're not going to let anything in there about a previous,
Yeah, that was kind of that was black and white.
Well, I mean, it made
that's bright line law.
That's why the guy was the defendant was probably chose to try the case.
But you're right. So many people were refusing, and so many attorneys were telling their clients, "Don't take the test." That the legislators decided, well, we can't have this.
Sure.
We got to change the law, and this is what it's progressed into.
Well, we're not here to give legal advice, but there's a little common sense out there that goes along with the state of the law that anybody who's watching who winds up in this unfortunate situation, you might want to think this over real carefully before you not take that test, because you particularly...
There's some penalties.
Well, if
you strict penalties now.
The person who's going to be maybe going to be leaning towards not taking the test is somebody that knows, he or she knows, I already got one on me, so I'm not going to take this test. Well, the way you've just explained it, that's all coming out in the wash, so to speak, here.
And the jury will know that.
The jury will know it, and consequences for that might be much worse
than just taking the test.
Sure, because high end, low end, whatever. Judge, there's something called, and I'd really like for you to explain this to me and to our viewers. It's called an administrative license suspension. Sometimes the alphabet soup we call it ALS. What's that mean?
Basically, an ALS is an administrative license suspension. It's a pre-trial or pre-conviction license suspension. Okay?
You mean you get punished before you get your day in court?
Yeah, absolutely. Absolutely.
How could that be?
The legislator created it. That's what it is. For example, on a first offense DUI, besides jail, there's a minimum license suspension. On a first offense, if convicted, it's a minimum 180 days to a maximum 3-year license suspension. But there's a hard suspension of 15 days. That hard suspension means from the day that you get cited, I cannot give you driving privileges. So even if you work, for the first 15 days, you can't drive.
The day you were cited?
From the day of the citation. You're not even in court yet.
You hadn't seen this
inside
the courtroom.
From the day you get cited for 15 days, you're not convicted of anything, but it's called a hard suspension. You cannot drive. And I, as a judge, am not allowed to give you any driving privileges for the first 15 days. That's a hard suspension. On a second offense, that's 45 days, and on a third offense, it's 180 days with no driving privileges.
So from the point where
you get stopped and ticketed.
At the stop and ticketed, our defendant is not driving that car home. I mean,
no. He's not driving to work.
Driving anywhere.
He can't drive to work.
For a first offense, 15 days.
15 days, yeah.
And there's really no exceptions on that?
There's no exception.
Because if a judge can't order it...
We cannot order it. It's a hard suspension. Now, take that ALS, again, administrative, it goes a step further. So we look at the ALS is if you take the test and fail it, okay, or if you refuse to take a test, okay? So on a first offense OVI, if you refuse to take the test, like I say, it's a 1-year suspension, no driving privileges for 30 days, okay? If you take the test and test a .08,